This is part 8 as far as our lecture series is concerned. In this part, as I had told you earlier, in the earlier part, that we intend to discuss some of the provisions of the Criminal Procedure Code, so that when you understand Indian Penal Code, for the purpose of implementing the provisions as far as the Indian Penal Code is concerned, we have to refer to the provisions of the Criminal Procedure Code of 1973. Now, up to this time, we have learned to a certain extent what do you mean by an offense, what do you mean by substantive law, what do you mean by procedural law, what is the distinction between legal duty and moral duty, what is the distinction between intention and motive, are some of the aspects with which you are dealt. And then we have also learnt one thing, that in order to study a particular enactment, by merely reading that enactment, it is not possible for you to have a holistic approach. In order to learn law in totality, it is necessary, as and when required, that you have to refer to the different provisions, not in detail. And for the purpose of understanding those provisions, let me tell you one thing which is very secret. You may not know the entire law, but when you are dealing with the provisions of it, when you come across a situation, if you go on reading to those provisions, that will definitely serve purpose of understanding, because law is such a vast subject that nobody can master the same. Hence, if you start doing this work simultaneously, as you are dealing with the provisions of the Indian Penal Code, and you learn whatever I have told you regarding Criminal Procedure Code today to a certain extent, during course of time, when you are reading a case law, you come across a provision as far as the provisions of the Indian Evidence Act is concerned, you can read those provisions, and then once you have inculcated this habit of learning of your own, that is definitely going to pay you in the long run, of which you should take serious note. Not only note, but I personally appeal to you from the bottom of my heart, implement it in its spirit, so that the purpose is likely to be served. With this now, imagine a situation where you are standing at a particular point of time, and the offense, namely one offense of murder has taken place in your presence. What you are expected to do? 2. Imagine a situation where you are standing and somebody has given slap to somebody, has pushed somebody, and has committed the offense of voluntarily causing hurt defined by section 321 of the Indian Penal Code. What you are expected to do? And imagine a situation where somebody has committed offense of defamation by saying that Professor Deshmukh cannot teach. He tells you in your presence, or he tells you that I thought Professor Deshmukh is a good teacher, but he is not at all a good teacher. What you are expected to do? Under such circumstances, mind well, you want the person who has done an act which amounts to an offense should be punished by the court of law. And in order that he should be punished by the court of law, your role is entirely different. And what is your role? In case when the offense of murder has taken place in your presence, you can go to the police station and set criminal law into motion by following the procedure which is laid down as far as subclause 1 of section 154 of the Criminal Procedure Code is concerned, by lodging what is popularly known as FIR, First Information Report. If at all you want to know the details, you can have reference to my part of the lecture with which I have dealt in detail as far as section 154 of the Criminal Procedure Code is concerned. Because I have already, as I told you, uploaded 56 parts as far as Criminal Procedure Code is concerned on the YouTube. And this is the time when you can refer to that. But this is just hint. What is the hint? Now, why he can go to the police station is the next question. And for that the simple answer is because the nature of the offense is cognizable. In other words, when the nature of the offense is cognizable, one can set law into motion by following the procedure which is laid down as far as subclause 1 of section 154 of the Criminal Procedure Code is concerned. And then, in order to know whether it is cognizable or not, how it is possible for you to find out. Details you can work out when you will deal with the process of the Criminal Procedure Code, but the time for me to tell you In order to know whether the offence is cognizable or non-cognizable, you have to, though this is murder is defined by the provisions of the Indian Penal Code, as far as to find out whether it is a cognizable or non-cognizable, it's not Indian Penal Code. You have to refer to the provisions of the Criminal Procedure Code. You have to refer to, when you start reading Criminal Procedure Code, you read right from section 1 up to section 484, and after that you come across first schedule of the Criminal Procedure Code. There is also second schedule of the Criminal Procedure Code, with which you are not dealing at present, but when you start reading first schedule of the Criminal Procedure Code, then you come across fourth vertical column. Now there you won't find out murder, no. In the first vertical column of the first schedule of the Criminal Procedure Code, you come across that section of the Indian Penal Code which does not define an act which amounts to an offence, but as per which the person can be charged and convicted by the court of law. So here you will come across section 302, and when you read fourth vertical column, immediately you will come to know whether it is a cognizable or non-cognizable. In other words, in order to know whether the offence is cognizable or non-cognizable as they are defined by the provisions of the Indian Penal Code, it is the only place where you can find out where there is classification of the offences, namely under cognizable and non-cognizable, is to refer to fourth vertical column of the first schedule of the Criminal Procedure Code. So as the murder is a cognizable offence, you can set law into motion by following the procedure by lodging what is known as the FIR as per subclause 1 of section 154. And then further part of the story is taken care of as far as Criminal Procedure Code is concerned. Investigating officer will start with the investigation. He will try to collect the evidence. He will try to find out, try to arrest the suspected person, and all those details are worked out, because at present we are not dealing with, but I am merely trying to tell you that anybody can set criminal law into motion is the basic principle of the criminal law. And how one can set criminal law into motion is entirely depends upon the nature of the offence. Cognizable offence, yes, this is the procedure that you can follow. Now when the offence, second situation, when the offence of voluntarily causing hurt has taken place in your presence, and if you go to the police station, the police officer in charge of the police station is bound to tell you, as the nature of the offence is non-cognizable, this is non-cognizable offence, not section 321, no. For that, when you refer to the first vertical column, the first schedule of the Criminal Procedure Code, you come across right from section 323 up to section 338 of the Indian Penal Code, where the punishment is laid down, maybe for the offence of voluntarily causing hurt, maybe for the offence of voluntarily causing grievous hurt under different circumstances accordingly. So these are the sections which deal with punishment. So you go to the police station and you start telling that such and such offence has taken place in your presence and you want to set law into motion. The officer in charge of the police station is bound to tell you, I am not telling you detailed procedure, but I am merely telling you that once you go there, mind well, now this is the time where the police officer in charge will tell you, as the nature of the offence is non-cognizable, I have neither right to arrest nor to start with the investigation. In other words, I cannot do anything in this matter. And then you ask him, I want to set law into motion because I believe in one principle, no offence should go unpunished is the basic principle of the criminal law. Somebody has to do something, otherwise everybody has to do everything, otherwise the object of the criminal law is likely to be defeated, and hence you tell him accordingly. And he will tell you, if this is the case, please follow the procedure. You can't follow the procedure as it is non-cognizable offence and not cognizable offence. You cannot follow the procedure which is laid down as far as subclause 1 of section 154 of the Criminal Procedure Code is concerned, but follow the procedure which is laid down as far as subclause 1 of section 155 of the Criminal Procedure Code is concerned, namely he will refer you to the magistrate. So you have to go to the magistrate and lodge complaint with the magistrate. Now this is a time, mind well, as a student of law, remember this forever. Details can be worked out when you deal with the provisions of the Criminal Procedure Code, but this is what is known as complaint to the magistrate. Complaint is never to the officer in charge of a police station for the simple reason, if you read section 2D of the Criminal Procedure Code, which says complaint is an allegation which is made orally or in writing to the court of magistrate with the view that he should take action that some person whether known or unknown has committed an offence. So complaint as defined by the provisions of the Criminal Procedure Code is always to the court of magistrate. So you go to the magistrate, you tell the magistrate, it may be in writing, it may be orally, whatever it might be, and then rest of the steps are taken by the magistrate. He will immediately tell the police officer to start with the investigation, and rest of the details with which we shall be dealing, or you can understand when you read the provisions of the Criminal Procedure Code. So setting criminal law into motion entirely depends upon the nature of the offence. Cognizable, FIR; non-cognizable, as I told you, complaint, and you have to follow the procedure which is laid down as far as subclause 1 of section 155 of the Criminal Procedure Code is concerned. With this now, the last situation, somebody has committed offence of defamation. And who is defamed? Professor, from your point of view, Professor H.P. Deshmukh is defamed. Now if you read section 499 of the Indian Penal Code, which says, whoever by words either spoken or intended to be read, or by signs or by visible representation, makes or publishes any imputation concerning any person with intent to harm, knowing or having reason to believe that such imputation will harm the person's reputation, he is said, except in the cases hereinafter accepted, to defame that person. We will come to this section. During course of our lecture, we will try to understand what this is an offence. Indian Penal Code takes care of your body. Indian Penal Code takes care of your property. It takes care of your reputation too. So the classification of offences is accordingly. So this is now you feel that it harms Professor Deshmukh's reputation, and you want to punish the person who has said Professor Deshmukh is not a good teacher. Naturally, you don't know details. So what you will do? The first thing that you will go, you will immediately go to the police station. Now 499 of the Indian Penal Code defines the offence of defamation. Section 500, 501 and 502 are the sections which deal with punishment. So now once in the first vertical column of the first schedule of the Criminal Procedure Code, you will never come across section 499. You will read section 500, 501 and 502 as far as the first vertical column of the first schedule of the Criminal Procedure Code is concerned. So what you do? You go to the police officer in charge of a police station, and he will naturally tell you, well, you want to set law into motion regarding an offence of defamation. Somebody has defamed Professor H.P. Deshmukh, but if you read the fourth vertical column, you will come to know that this is a non-cognizable offence. And because of the fact that it is non-cognizable offence, he will direct you to go to the magistrate to lodge a complaint by following the procedure which is laid down as per subclause 1 of section 155 is concerned. You go to the magistrate. Now once you go to the magistrate now, the magistrate will say, well, I cannot take cognizance of this offence because of section 199 of the Criminal Procedure Code. And what is that? It says when the offence is that of a defamation, it is only the aggrieved person who can set law into motion. So now who can set law into motion as far as this section for offence of defamation is concerned? Only Professor Deshmukh can set criminal law into motion. Nobody other than Professor Deshmukh can set criminal law into motion. Details can be worked out at the time of discussing section 199 as far as Criminal Procedure Code is concerned. This is not the time, but I am merely trying to tell you. When you come to know that somebody has committed an offence, right from section 493 up to 498 of the Indian Penal Code, offences relating to marriage. In that case also, it is not that anybody can set criminal law into motion as per section 198 of the Criminal Procedure Code. Please don't have confusion regarding sections as far as Indian Penal Code is concerned and Criminal Procedure Code is concerned. Even if you forget this, no problem. But during course of time, you must be in a position to know that in order to implement the provisions of the Indian Penal Code, the law that you should know is the provisions of the Criminal Procedure Code of 1973. That is the mechanism. It lays down the mechanism that you must be doing, and this you can start learning simultaneously also. So as per section 198, it is only when the offence is relating to marriage who can set law into motion. It is only the aggrieved person who can set criminal law into motion. Nobody other. Magistrate has got no power to take cognizance of an offence unless there is complaint on the part of the aggrieved person. Now this chapter with which I have already dealt with, we shall be dealing as and when it is necessary, no doubt about it, but try to understand this is what is required to be followed. One more aspect which I want to make clear: if it happens that somebody commits the offence, he is arrested by the police and next day he meets you on the road. You think, well, yesterday he had committed an offence and how is that he is here on the road? As a student of law, remember one thing, that if you read 5th vertical column of the first schedule of the Criminal Procedure Code, you come to know whether the offence is bailable or non-bailable. And in order to know details regarding the same, you have to read right from section 436 up to section 450 of the Criminal Procedure Code, which deals with provision regarding bail and bonds. And there you will come to know that person, for example, if he is arrested and accused of an offence of which nature is bailable, he can claim bail as a matter of right. What is bail? Releasing person from a legal custody subject to certain conditions which are required to be followed. For that you can read section 438. 36. If it is non-bailable offence, you cannot claim bail as a matter of right, but that is at the discretion of the court of law, and rest of the details are worked as far as section 437 is concerned. So this is what is bail. Bail is releasing person, and bail presupposes what? Arrest. And what is an arrest? Arrest is an encroachment with respect to the personal liberty which is guaranteed by Article 21 of the Constitution of India, which says no person shall be deprived of his life or personal liberty except according to the procedure established by law. So this is, as this is the way in which you should go on learning accordingly. As and when it is possible, I shall be making mention of everything, no doubt about it. But it may not be possible for me to cover everything. But once you have, by listening to my lectures, if you develop this practice, that well, for the purpose of understanding law, it is not we are going to concentrate only on particular section with which you are dealing, but we should try to correlate the section or correlate this Indian Penal Code with that of other laws. Then only it will be possible for you to have good approach as far as understanding of the law is concerned, of which again I repeat, you must take note and implement it accordingly. With this now, during course of time, you may be required when you are expected to go through the case law. Because case law might have laid down the law, you will read and try to understand the provisions of the Indian Evidence Act. Now you can understand Indian Evidence Act when you start reading the provisions of the Indian Evidence Act of 1872, for which you have to start right from section 1 up to section 167 of the Indian Evidence Act. During course of time, you will come to know what do you mean by relevant, what is relevant, what is admissible, what is not admissible, what is admission, what is confession. All these terms, who is a competent witness, what do you mean by examination in chief, what do you mean by cross-examination, what do you mean by re-examination. All these you will come to know. What do you mean by oral evidence, what do you mean by primary evidence, what do you mean by documentary evidence, what do you mean by public document, what do you mean by private document. All these things you will start learning as and when it is possible. You refer to the provisions of the Indian Evidence Act. I shall draw your attention to some of I have already drawn your attention to section 105 as far as burden of proof is concerned, when I told you importance of general exceptions right from section 76 up to 106 of the Indian Penal Code. Now this is the time where I want to draw your attention and tell you, when we shall be dealing with section 375 of the Indian Penal Code, which defines the offence of rape, I will draw your attention to section 114A of the Indian Evidence Act, which was an amendment to the Indian Evidence Act in the year 1983. At the time of understanding section 304B of the Indian Penal Code, which defines the offence of dowry death, I will draw your attention to section 113A and 113B of the Indian Evidence Act. So as and when I will refer to the provisions of the Indian Evidence Act, no doubt about it. As it's not only Indian Evidence Act, my dear students, I shall be drawing your attention to the provisions of the constitutional law. The next lecture, we are going to deal with first chapter of the Indian Penal Code, dealing with intra-territorial and extra-territorial operation of the Indian Penal Code. And when we shall be dealing with, what is, can you arrest President of India? Can you arrest Governor of a particular state? Can there be a criminal prosecution against him? And for that, it is necessary for you to read Article 361 of the Constitution of India. So, at times, I may be drawing your attention to some of the provisions as far as constitutional law is concerned. Yes, we shall be doing that. But, try to understand my limitations. It may not be possible for me to work out all the details, but you can't say, well, we don't, because you want to, you want to make your career as far as law is concerned, and then whatever may be the situation which you are facing, maybe because you are practicing in a court of law, maybe because you are working in a corporate field, whatever it might be, but when you are dealing with the provisions of the law, this should be your approach. When we talk about witness, there can be, as far as criminal law is concerned, there can be witness on behalf of the prosecution, there can be witness on behalf of the defense, but there can be court witness also, as far as section 311 of the Criminal Procedure Code is concerned. Generally, we say accused person is not a competent defense witness. Yes, he cannot be compelled, but then if you read section 350, if he makes an application that he wants to become a witness on behalf of the defense, by all means there is a provision which is made very clear when you read the provisions of the Criminal Procedure Code accordingly. So this is the manner in which you should, when we talk about criminal law, or whether it is a civil law, whether you need a particular number of witnesses. I know that is made very clear as far as section 134 of the Indian Evidence Act is concerned, that no particular number of witnesses are required to prove any fact. No, certainly not. And what is the procedure that court has to follow? If it is a criminal law, court will follow procedure as far as the Criminal Procedure Code is concerned. If it is civil law, court will follow the procedure as far as the Civil Procedure Code is concerned. And if it is not mentioned over there, that is entirely at the discretion of the court of law, which is made very clear as far as section 135 of the Indian Evidence Act is concerned. So as and when it is necessary, as and when it is required, as and when it is possible, as and when it is must, I shall be doing, no doubt about it. But now, if you learn this right now and start understanding, then don't say this we are going to deal afterwards. No, start simultaneously studying the same so that your understanding of the law becomes clear. And let me tell you one thing, remember one thing forever in the life: clarity and simplicity, they go together. When there is no confusion, communication is never a problem. And if you have clarity, there won't be any confusion, then communication won't be any problem, and that is your role in the capacity of a student of law, that you want to make the point very clear to the person with whom you are dealing, whoever may be the person. I am not referring to only working in the capacity of an advocate, whatever may be your capacity, but as a student of law, when you are expected, this should be your approach from the point of view of studying the same. For which I take this opportunity to have this approach, for which I wish you all the best. From next lecture onwards, we shall start dealing with each chapter of the Indian Penal Code in detail.